Now turning our attention to the rape case against former prosecutor Gary Zerola. Former attorney is facing sentencing after being convicted of rape last month. Prosecutors say after a night of drinking, Zerola entered a 21-year-old victim's apartment, and when she woke up, he was raping her. The victim was not present for today's sentencing, but the prosecution told the court that that was no reflection on the case. Let's head back into court for more of that hearing.
He also, with a Boston police officer, Andrew Biggio, started the Boston Wounded Veterans Charitable Motorcycle Run. They raised a lot of money for veterans that had been wounded. I know you have the letters. I wanted to make a quick comment on that because and I don't mean to suggest that the government tried to assert a negative from it, but irrespective of someone's past, the court should consider whether or not there will be a support network, and there is. And this is a support network that Mr. Zerola has earned over the course of his lifetime. These people didn't just show up for the heck of it or because they had nothing better to do. You might recall a letter from a Robert Walsh. Robert Walsh had a conversation with Mr. Zerola one day, and he had mentioned to Mr. Zerola that friends of his that Mr. Zerola didn't know had no home heating oil. And Mr. Zerola, without any prompting, paid the bill for the home heating oil. Now, Mr. Zerola didn't do that because he thought someday that would help him before Judge Ames at a sentencing hearing. Mr. Zerola didn't send out press releases regarding that. And that was only one out of thousands of similar acts. Mr. Zerola did it the way it should be done, silently, because it was the right thing to do. I can tell you, as early as this morning, I was telling people that Judge Ames is a stickler for deadlines. The deadline has come and gone for the sentencing memo because I was still receiving letters. I don't want to hyperbolize, but I'm probably at about 100 letters right now sent in support. And these come from all walks of life. These comes from...
Counsel, if you wish to submit further documents, letters, or anything else, I'm happy to receive it.
Thank you. I knew that you would probably, knowing that you're diligent, had read the memos. I didn't want to be sending things at the last minute because I didn't want the court to think that I didn't take your deadline as serious. But the point being is, sure, some of these are clients that he skillfully got out of harm's way, but a lot of them are clients that came to him and said, I can no longer pay you. And Mr. Zerola, I've never come across a client where he filed a motion to withdraw because money became an issue. There are neighbors, there are people that were friends with his mother is of failing health. She's too old to come, but one of her sisters has been here every day, and Mr. Zerola refers to her as his mother. And these are people that he has, again, earned this with. So that's certainly something the court should consider. The court should consider not as a negative, conversely, as a positive factor, Mr. Zerola's age. And I'm going to say a little bit more about that like this. You know, when you're trying to formulate what an actual number is, and you do not necessarily a quantitative, but a qualitative analysis, there's really two ways to do it, right? You can assign each day a unit, and there's two ways they do it in mathematics. One is they call it a constant, but two, they call it a variable. And I'm asking you to consider it as a variable. And what I mean by that is not every day in prison, incarcerated, is the same. Not every day that Mr. Zerola is presumably going to serve, because we haven't even asked for probation, is going to be the same. But if you extend that argument, not every prison day is the same for every person. And what I mean by that is, if you were a 25 or 26-year-old with a clean bill of health, and you were being sentenced to prison on a drug or gun-related offense, that is still going to be a very difficult time. I go to these prisons. I've never served a prison sentence, but I hear the stories. I see the stories. Prison, despite what some people might see or read or hear, is a very difficult place. It is a violent place. It is a scary place. It is a psychologically traumatizing place. Criminals are not coddled, and I don't care what any member of the media says to the contrary about that. So as difficult as that would be for someone, say, 25 or 26, that's going in on a gun offense, think of how difficult that is going to be for someone who is 52 years old, and let's not ignore it, going in convicted of a sexual offense. Mr. Zerola, I didn't know him when he was 25, but certainly is now 52 years old. You know from the pleadings that he has significant health problems. He is suffering from a rare and aggressive form of eye cancer, ocular cancer. And Mr. Pollenbaum, and I don't think that he did this nefariously, but suggested that there will really be without limitation his treatment. That couldn't be further from the truth. Mr. Zerola sought and received treatment in Massachusetts for his eye cancer, and despite having some of the best and brightest people in the field in the entire world, even they said it was too rare for them and they didn't feel comfortable because they didn't have enough experience treating it, so they had all recommended and referred him to Dr. Shields in Philadelphia. Now, you know, Judge, that he had went and saw Dr. Shields, and Mr. Zerola did not want to further delay the trial for anyone, and we didn't press after the court was gracious enough to let him take that appointment to seek any further delay. But Dr. Shields, although certainly while she confirmed the findings that the surgery was not successful, that cancerous malignant tumor remains in his eye, and she did cite some growth, but not, overnight growth, still her prognosis is fairly dire, and the recommendation was for Mr. Zerola to go back to Philadelphia as soon as he can. No rape is good. And so while I don't minimize that, what the jury found, that, again, we can't, and I agree with the Commonwealth, we can't parse out or extrapolate exactly what they were thinking. We don't know if they found that she was actually awake, but the stupefaction instruction had some credence to it. We don't know. But we do know that no rape is good rape, but the allegations, to the extent that they were proven in this case, certainly don't distinguish them from another type of rape, a rape where perhaps a woman is accosted in an alleyway, or a woman is forcibly raped and suffers beating during the rape. So there's nothing unique about these facts that would warrant such a departure, and it actually cuts against all of the work that the Guideline Commission did. To the contrary, and I don't think age should play a role, but to the extent, again, there is optics involved, if there were two college kids in a similar circumstance in this case, I'd probably be asking for house time. Now, when we talk about, one other thing I wanted to talk about is rehabilitation. Certainly there was evidence of alcohol use and drug use by Mr. Zerola as well. And that's something that the guidelines talk about the court should consider. Mr. Zerola has been on conditions of release since the inception of this case for the better part of 3.5 years. He was outfitted with a scram device, and he was required initially, I believe, 4 times, and it was reduced to 3 times when the medical issues came up, to have his blood alcohol content or his through sweat, whatever the scram device monitors, tested. Probably estimating about 3,000 scram tests were performed, and not on a single occasion did it detect that Mr. Zerola had consumed even a sip of alcohol in 3 years, which shows that he recognized the seriousness of the offense that he was charged for. He recognized that a judge, and I don't believe you set the first conditions, but that it was an order of a court he had to follow, and he followed it. And he followed it to a T. And certainly, DOC has done a much better job in getting progressive with addressing rehabilitation. I know, again, anecdotally from other clients, there is now meaningful opportunity for him to afford himself of all kinds of counseling. Obviously, with his degrees, he doesn't need the vocational training. He would take it if he could. They'll probably have him be a teacher. But certainly there is dual diagnosis, there's substance abuse, drug abuse, alcohol abuse, anger abuse. There's as much programming as the person wants. And knowing Mr. Zerola, he will be ambitious about it, he will be vociferous about it, he will be prolific about it, and he will do that. But the point being is the court has a pretty good body of evidence over the past 3 years that you're outfitted with a bracelet, you're on home confinement, you cannot have a sip of alcohol, and he's done it. And I know that I've talked to his probation officer. He is dutifully reported in person, by phone. He's coordinated with them the medical treatment, everything he was supposed to do. So there's a pretty good history that he knows he can't drink. He knows rehabilitation has to be part of the process.
The defense attorney there treading really lightly with the judge, trying to give his definition of the difference between a date rape and, to use his words, an alley rape. But he runs the risk of inflaming this judge, of trying to say there are levels or a lesser type of rape. When we come back, the defense attorney is going to wrap up his argument, and then we'll watch together the judge's ruling. Keep it right here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, Ashley Benefield is days away from going on trial for shooting her husband. Did she shoot in self-defense or in cold blood?
Closing Arguments, tonight at 8/7 Central, only on Court TV.
She could hear the bat hitting her father.
Michael was under the influence of Courtney.
And Michael Moore is not the person who killed my father.
Accomplice to Murder with Vanny Politan, Sunday night, 8/7 Central, only on Court TV.
Welcome back to Court TV Live. We are wrapping up our coverage in the sentencing hearing of a former prosecutor, Gary Zerola. A jury convicted him of rape last month, and his attorney, as we're watching, is wrapping up his argument for leniency. And after that, the judge will issue her ruling.
2 to 3 years is going to be exceptionally, and I know his family members probably don't want to hear this, 2 to 3 years is going to be exceptionally difficult and dangerous for Mr. Zerola. He is going to probably, on a daily basis, have to deal with comments, some of them on the threatening side. He probably, on too high of a frequency, is going to have to deal with physical confrontations, and he's going to have to survive. He's going to have to survive the cancer, and he's going to have to survive for the charge for which he stands accused of. The parsimony principle is something that's been recognized in federal court, and I believe in language, Rodriguez and some of the other cases in state court, that stands for the proposition that a sentence should be sufficient but not greater than necessary. Again, every day is difficult. I respectfully ask that you sentence to Mr. Zerola to no more than 3 years, no less than 2 years in state prison. And I know it has no legal binding authority, but I ask that you recommend Norfolk, because I believe they probably are the best equipped medically to deal with patients that have serious conditions.
Thank you, counsel.
And my client, one last thing.
Sure.
I don't want and I know your experience, you won't take it as a lack of contrition. Obviously, with a pending appeal,
yes,
Mr. Zerola cannot get up and make any type of statement. And I know you know it. You've been doing this for a long time, but I have to say it. Please don't mistake that for
I
a
was
lack
going
of
to
contrition.
ask you if he wished to allocute.
He does, but I've advised him that he cannot.
And that is not surprising, and this court, it's probably a very prudent step. And I understand that that doesn't mean that he doesn't wish to speak, but at this point with an appeal pending, ought not to speak.
Thank you.
Thank you very much. I have read very carefully and repeatedly and considered the memoranda of the Commonwealth and the memoranda of the defense. I have now listened very carefully to the statement of the victim in this case, and I have read more than once the letters of support, particularly the letter of the brother that laid out the circumstances of Mr. Zerola's life. I have also considered the acts and circumstances for which he was convicted in this case. It is this court's judgment that a sentence of not less than 5 years, not more than 10 years, is warranted by these facts, and the court imposes a sentence of 5 to 10 years in this case. Madam Clerk.
Thank you, Your Honor.
No, impose everything.
Okay.
Please. You're welcome.
Mr. Zerola, as required by statute, I must inform you that the records regarding the charge for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court, unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you must use the request not to seal form. A copy of that form has been left with counsel at defense table. I cannot accept the form here in court. You must submit that to the Commissioner of Probation at the address provided on the form. Please be aware that if records regarding the charges for which you have been found not guilty are sealed, you will be unable to access the sealed records of the not guilty disposition or any records regarding to those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request those copies from the court within 10 days. Do you understand that, Mr. Zerola?
Yes, Madam Clerk.
Okay.
The record shall also reflect, and then I'll give you a chance to impose the sentence, that it is the court's recommendation that the sentence be served in Norfolk County. Go ahead, Madam Clerk.
Mr. Zerola, the jury having returned a verdict of guilty as to indictment number 2184 CR 00072 to offense 001 to the lesser included offense of rape, the court sentences you today to a term of not more than 10 years, not less than 5 years. That sentence to be served at Norfolk at your request. The court is imposing the DNA fee of $110 as well as the victim witness fee of $90. You're being notified that pursuant to Rule 64, you have a right to appeal this sentence to the appellate division in writing within 10 days, and that's pursuant to Rule 64. You're also being notified that you have a right to appeal the conviction within 30 days pursuant to Superior Court Rule 65.
Attorney Gary Zerola there. You see him discussing things with his attorney. He understands this process well because he himself is an attorney. Let's bring in two trial attorneys to help us break down what we are seeing here. Wendy Patrick and Michelle Thomas are with us. Michelle, your thoughts on 5 to 10 years for this defendant who was convicted on one of the charges but acquitted on the top ones, the aggravated rape and the burglary work he was acquitted on, but convicted on the rape charge against him.
Good evening, Julie. I think that was appropriate. I mean, the defense was asking for just 2 to 3 years under the, I think, mitigating factors argument that jail was too harsh for him and he had a great support system and this rape occurred. It wasn't the same type of rape that occurs in an alley. And quite frankly, those arguments are offensive. Rape is rape. And I'm quite certain that this 21-year-old victim at the time felt that she was in danger and felt that she was should not have been subjected to the horror that she experienced that's going to haunt her for the rest of her life. So I do think that the 5 to 10 year range is appropriate. The court certainly gave consideration, giving him the recommending a specific facility that he requested. He is a former attorney, but I think that that's really an appropriate sentence given the crime of which he was convicted.
Yeah, Wendy, this is a defendant who asked about getting a specific placement when it comes to where he's going to serve out his sentence because of an eye cancer that he has. Is that typical that a judge approves that, as it seems like has been done in this case, or the Department of Corrections approving where they want to go? And anything else standing out to you about this particular sentencing?
That remembering my years as a criminal defense attorney, this has got to be one of the most challenging types of sentencing hearings that you appear at when you're talking about rape, sexual assault. There is no way to describe it that is not offensive. This is one of those crimes that across the board, I mean, criminal defense attorneys are just as disgusted. They have families too. So what you heard here was good guy evidence. He's a former lawyer, he's turned over a new leaf, he doesn't drink, and really trying to mitigate this case through proving credibility through compliance. He's done what he's supposed to do. He's following the rules. But it's just so hard to undo something this significant, especially, you would think that having this type of a career would be a mitigant. It's an aggravant. It's one of those things that you just can't argue it away. This is somebody that should have known better. And to talk about, well, he's not the same kind of a person when he drinks versus doesn't drink, that's a dangerous proposition should he have a drink again. So I think the judge, given her experience, did probably what the defense attorney and his client already knew she was going to do, is didn't impose that lesser sentence, because you got to consider the victim and the facts of the case as well.
Her Honor has spoken, and the appeal is pending. So we will see what happens next for Gary Zerola, as he is now going to be moved into this incarceration that he's been sentenced to. Michelle and Wendy, stand by. We are going to shift our